There are times when there's a list pending out on the property. That means that there's a current matter going on in the court in relation to these land. There's a pending suit, all right? And currently the power and control of the property is no longer in the party's name, but is pending the continuance of the action by the court and waiting final judgment. So therefore that land is not free and unencumbered to be sold. Then we also have mortgages. When you mortgage property, ladies and gentlemen, you no longer are the owner. I think a lot of persons do not understand that. And I want to repeat myself. When you mortgage a property, you are no longer the owner. The institution or party to whom you mortgaged now currently holds ownership until the mortgage has been satisfied, and therefore the property is released from under the mortgage. And I've seen many persons attempt to sell land that are mortgaged. However, if you wish to do so, there is a provision for, and this is why I say to have your sale agreement done by an attorney at law, so that if it can happen, if the mortgage, the encumbrance is expressed, right? Perhaps you have a mortgage and it is almost finished, or the purchaser has no problem buying the mortgage or taking the mortgage over from you. But these things have to be expressed and represented for in the sale agreement. All right. We're going to talk about different ways people could have title just now, because it's very interesting there. I want to just skip forward now to after title searches. Right? After title searches, we need a valuation done. Now, the vendor may set their price. They may not need. Do we have Miss Sobers with us? No? All right. The vendor is not obligated to have a valuation. However, it is helpful because it solidifies your ask. It verifies that this is in fact the value for what, or it is at least close to the asking price for it. But it is not the obligation of the vendor to have a valuation done. The valuation is in the interest of the purchaser. You want to make sure that the value of the lands is in fact that value, and more than that, you require a valuation to establish your stamp duties associated with the transaction. That brings us to our next point. After the valuation, you have to take the valuation, and according to the type of property that is being transacted, you require tongue and country approvals, right? WASA clearance certificate. You may require regional corporation certification as well. And you're using your valuation to carry into the stamp duties division to have the instrument stamped and the duties paid accordingly. After this is done, then the document, the instrument of title, is carried to the Ministry of Legal Affairs in order to be registered. A registered instrument of title must have several things, including the name, occupation, and address of the parties, an explanation and details on how the vending party came into possession of title, the consideration, if it is a conveyance, being paid, and the manner in which the interest or the title is being transferred to the other party. What do we mean by that? And that's where we come into talking about different types of interest. If you have a freehold interest, you can sell your freehold interest completely. If you have a freehold interest, you can lease your interest in a manner prescribed. If you have a freehold interest, you can transfer your interest in fee tail to the other party. If you have a freehold interest, you can gift, etc. You must describe the manner in which you are given the interest, the manner in which you had the interest, and the tenancy as well. So sometimes if it is more than one party purchasing the land, you have more than one purchaser, you have to outline Well, this is all things for the attorney to know, of course, right? Tenants in common or joint tenants. And the other part of the deed, so all of these that we are speaking about is the recitals. You're going to recite how the vendor came into possession and then you have your whereas or actionable clause where you have that is being passed in what manner. And then you have the schedule, and the schedule part of the instrument of title. Notice I'm not saying deed, because not all instruments of titles are deeds, all right? So in that instrument, you must have the schedule portion of it that identifies the features of the land, the features of the parcel, where it is situated, the size of it, and usually square meters are used. We cannot be using a measuring tape to measure land. And I'm saying this because I am referring to real life things, that has come to me before, right? You cannot use measurements from a measuring tape to include in any instrument of title or sale agreement. You require that a licensed surveyor have detailed or delineated the boundaries of the land, and or you have received the description from a instrument of title before it that has been verified, right, by a licensed surveyor, that the boundaries are described and detailed, north, east, west, and south, the size of each boundary, and where the parcel was excised from if it was from a larger portion. Now, if the parcel is being excised or taken from a larger portion and it is under old law, meaning it's a deed, a cadastral usually, or what people call a cadastral, is really a sketch, right? Or a plan. A plan is attached that draws out the boundaries as described in the scheduled portion of the deed. And the shaded portion or the portion mark, you usually may see a demarcation referenced in the description. They may say the parcel marked X, the parcel marked A12, or whatsoever is the subject of this instrument.